What is the legal definition of certainty, and is doing business on the usual terms going to be recognized as sufficiently certain? In this video, we'll discuss certainty as the fifth video in our six-part series that aims to answer the question of what makes a contract legally binding. Make sure to stay until the end of the video to find out whether you should include all of the terms relevant to the contract in that written agreement. But before we get started, let me just very quickly introduce myself. I'm Malcolm Zoppi, an English qualified solicitor and the managing director of Zoppi, my law firm. And on YouTube, my goal is to make business law easy. Amazing. Let's discuss certainty. A court will not enforce a contract to which no definite meaning can be given. So what does that mean? Well, if the terms of a contract are not sufficiently certain, it is not exactly clear what the parties are actually agreeing to, then the element of certainty is not there, and therefore a court will not enforce a contract whose terms are unknown. So, for example, if two parties decide to enter into a contract orally, so just speaking, and they say that it will be a hire purchase agreement, a court is going to be unlikely to enforce that oral agreement because there are too many kinds of hire purchase contracts to be sufficiently certain of what kind the parties intended to enforce. But what if the parties orally state to themselves, will enter into this contract on the usual terms? Is that going to be sufficiently certain? Well, it is a question of whether the previous usual terms are in itself sufficiently certain. If they are, then a court might be able to imply those terms into the existing agreement, therefore making the arrangement sufficiently certain. What about if we have a written agreement whereby the majority of the terms are indeed sufficiently certain, but there are certain clauses in there that are not? Well, a court might decide to ignore, also known as sever, that specific clause that is insufficiently certain. But before we move on to discussing whether all of the terms of the contract need to be included in the written agreement to have sufficiently certain terms, make sure to subscribe to my channel to continue to receive to the point, pragmatic and practical legal information. Also, if you want professional legal advice from a qualified solicitor, make sure to reach out. I have my contact details right below. The answer to whether all of the terms of a contract need to be written into that contract for certainty to be there is no, you don't need to do that. But there are conditions. So, for example, you need to be able to find that information very easily, for example, on a website, to be able to rely on that being part of the contract to then create sufficiency. So we've discussed all 5 main elements of a legally binding contract, but assuming that there are all of the elements present in an existing arrangement, there is still the chance that that contract is not going to be recognized as legally enforceable. To find out what makes a contract legally invalid, even if we have all elements present, make sure to watch this video right here.